Hello everyone, hope you guys doing well. This is my new video about the topic special kinds of contract. Hope you guys like this video and understand this properly. So let's get started. In today's video, we are going to discuss about the contract of indemnity and contract of guarantee. These contracts form a part of general law of contract. Therefore, the same general principles relating to the formation and discharge of contract apply to these contracts also. But there are some special features regarding these contracts which are discussed in section 124 and section 147 of the Indian Contract Act. So, talking about the definition of contract of indemnity, in section 124 says a contract by which one party promises to save the other from the loss caused by the conduct of promisor himself or by the conduct of any other person is called the contract of indemnity. Here, the person means the promiser to compensate is indemnifier, and the person who protected against the loss is known as indemnity holder or indemnified. So, there are basically two types of parties. For example, A contract to B against consequences of any proceedings which C may take against B in respect of certain sum of say rupees 200. This is the contract of indemnity. In simple words, a contract of indemnity is a contract in which one person promises to protect or compensate the other for the loss suffered by him due to the conduct of the promisor or any other person. Okay. Next is what are the essentials of contract of indemnity. So a valid contract of indemnity should fulfill the following conditions, like there must be two parties, the indemnifier and the indemnity holder. So the contract of indemnity is like a contract of insurance. Okay, a contract of indemnity must have all essentials of valid contract like pre-consent, consideration, lawful object, etc. There must be a promise to save the other party from some losses. The loss may be due to the promisor himself or any other person. The contract may express or implied. So these are the basic essentials of contract of indemnity which it needs to be fulfilled. Then the commencement of indemnified liability according to Indian Contract Act, there is no provision regarding the time of commencement of indemnifier's liability under the contract of indemnity. So we have to look for the answers in the observations of court in various judicial decision. There was a difference of opinion on the point among the different high courts. Some high courts have held the view that indemnifier is not liable until the indemnity holder has actually suffered a loss. On the other hand, some of the high court have held the view that indemnifier become liable to pay even before the indemnified had incurred actual loss. It may be noted that in this regard, the English law defines indemnity as a promise to save another harmless from the loss caused as a result of a transaction entered into the instance of the promisor. According to this definition, loss caused by events or accidents is also included. Although the definition of indemnity as per Indian law is restrictive in scope, as compared to this English definition, court of law in India have followed the English law relating to indemnity. So, there are certain rights of indemnity holder when sued, like all the damages which the indemnity holder was compelled to pay in any such suit in respect of any matter to which the promise to indemnify applies. All costs which the indemnity holder may be compelled to pay in any such suit if in bringing or defending it. he acted prudently or with the authority of the promisor. All the sums which he may have paid under the terms of any compromise of any such suit, if the compromise was not contrary to the order of the indemnifier, provided he acted prudently or with the authority of the promisor. This is all about the contract of indemnity. So let's move forward. Another contract is contract of guarantee. So basically contract of guarantee means giving a guarantee of one person to another person that he will prepay that so and so amount. According to definition of section 126 of Indian Contract Act, a contract of guarantee is a contract to perform the promise or discharge the liability of a third person in case of his default. The person who gives the guarantee is called surety. The person to whom the guarantee is given is called the creditor. The party in respect to whose default the guarantee is given is called principal debtor. So basically there are three parties. It is a triplet agreement which contemplate a principal debtor, a creditor and a surety. In it, there are three collateral contracts between the creditor and debtor, between the surety and creditor, and between the surety and the principal debtor. That principal debtor shall indemnify surety in case he is called upon to pay in case of default by the principal debtor. There are some essentials of contract of guarantees are also like requirement of a valid contract. The essentials of a contract like competence of parties, free consent, consideration, etc. must be present to make a contract of guarantee enforceable by law. Another is the contract must be supported by consideration. Like every other contract, a contract of guarantee must be supported by consideration. However, law presumes that consideration received by the principal debtor is sufficient consideration for surety. There need there need not to be direct consideration between the surety and creditor. Anything done or any promise made for the benefit of debtor may be sufficient consideration for the surety for giving the guarantee. There must be someone primarily liable. There must be uh, primarily liability on someone other than the surety. There must be someone liable as a principal debtor, and the surety undertakes to be liable on his default. If that liability does not exist, there cannot be a contract of guarantee. But a guarantee given for a minor's debt is exception to this rule. Okay. Next is there should be no misrepresentation. A contract of guarantee is a contract of absolute good faith. Yet it is a duty of the party taking a guarantee to put the surety in possession of all the facts likely to affect the degree of his responsibility, and if he neglects to do so, it is his risk. The last one is concurrence. A contract of guarantee requires concurrence of all the three parties to it. That is the principal debtor, creditor, and the surety. The surety comes into the picture at the request of principal debtor. So this is all for the contract of guarantee and contract of indemnity. Hope you guys like this video.